Welcome back to Part 4 of the Florida MPJE review. Let's continue, and please feel free to jump around if there are sections you already feel like you have mastery over. Standard of care. 1. The board shall adopt by rule standards of practice relating to the practice of pharmacy, which shall be binding on every state agency and shall be applied by such agencies when enforcing or implementing any authority granted by any applicable statute, rule, or regulation, whether federal or state. 2. Before dispensing a controlled substance to a person not known to the pharmacist must require the person purchasing, receiving, or otherwise acquiring the controlled substance to present valid photographic identification or other verification of his or her identity. If the person does not have proper identification, the pharmacist may verify the validity of the prescription and the identity of the patient with the prescriber or his or her authorized agent. Verification of health plan eligibility through a real-time inquiry or adjudication system is proper identification. BT. His subsection does not apply in an institutional setting or to a long-term care facility, including, but not limited to, an assisted living facility or a hospital to which patients are admitted. C. Is used in this subsection. The term proper identification means an identification that is issued by a state or the federal government containing the person's photograph, printed name, and signature, or a document considered acceptable. Now we will discuss registration of non-resident pharmacies. 1. Any pharmacy which is located outside this state and which ships, mails, or delivers in any manner a dispensed medicinal drug into this state shall be considered a non-resident pharmacy, shall be registered with the board, shall provide pharmacy services at a high level of protection and competence, and shall disclose to the board the following specific information. A. That it always maintains a valid, unexpired license, permit, or registration to operate the pharmacy in compliance with the laws of the state in which the dispensing facility is located and from which the medicinal drugs shall be dispensed. B. The location, names, and titles of all principal corporate officers and the pharmacist who serves as the prescription department manager for dispensing medicinal drugs to residents of the state. This disclosure shall be made within 30 days after any change of location, corporate officer, or pharmacist serving as the prescription department manager for dispensing medicinal drugs to residents of the state. C. That it complies with all lawful directions and requests for information from the regulatory or licensing agency of all states in which it is licensed, as well as with all requests for information made by the board pursuant to this section. It shall respond directly to all communications from the board concerning emergency circumstances arising from errors in the dispensing of medicinal drugs to the residents of the state. D. That it maintains its records of medicinal drugs dispensed to patients in this state so that the records are readily retrievable from the other business records of the pharmacy and from the records of other medicinal drugs dispensed, and E. That during its regular hours of operation, but not less than 6 days per week, for a minimum of 40 hours per week, a toll-free telephone service shall be provided to facilitate communication between patients in this state and a pharmacist at the pharmacy who has access to the patient's records. This toll-free number must be disclosed on the label affixed to each container of dispensed medicinal drugs. Feel free to pause the video at any point if you need to take a break. 2. Applications for non-resident pharmacy registration under this section shall be made on a form furnished by the board. The board may require such information as the board deems reasonably necessary to carry out the purposes of this section. The board may grant an exemption from the registration requirements of this section to any non-resident pharmacy which confines its dispensing activity to isolated transactions. The board may define by rule the term isolated transactions. 3. The registration fee and the biennial renewal fee shall be the fee specified. 4. The board may deny, revoke, or suspend registration of, or fine or reprimand, a non-resident pharmacy for failure to comply with any requirement of this section in accordance with this chapter. 5. In addition to the prohibitions of subsection 4, the board may deny, revoke, or suspend registration of, or fine or reprimand, a non-resident pharmacy in accordance with this chapter for conduct which causes or could cause serious bodily or psychological injury to a human or serious bodily injury to a non-human animal in this state. 6. It is unlawful for any non-resident pharmacy which is not registered pursuant to this section to advertise its services in this state, or for any person who is a resident of this state to advertise the pharmacy services of a non-resident pharmacy which is not registered with the board, with the knowledge that the advertisement will or is likely to induce members of the public in this state to use the pharmacy to fill prescriptions. 7. This section does not apply to Internet pharmacies required to be permitted under S. 465.0197. 8. The registered pharmacy and the pharmacist designated by the registered pharmacy as the prescription department manager or the equivalent must be licensed in the state of location in order to dispense into this state. International Export Pharmacy Permit. To participate as an exporter of prescription drugs into this state under the International Prescription Drug Importation Program established, a pharmacy located outside of the United States must hold an International Export Pharmacy Permit. An application for an International Export Pharmacy Permit must be submitted on a form developed and provided by the Board. The Board may require an applicant to provide any information it deems reasonably necessary to carry out the purposes of this section. An applicant shall submit the following to the Board to obtain an initial permit, or to the Department to renew a permit: proof of an active and unencumbered license or permit to operate the pharmacy in compliance with the laws of the jurisdiction in which the dispensing facility is located and from which the prescription drugs will be exported. Documentation demonstrating that the country in which the pharmacy operates has a current mutual recognition agreement, cooperation agreement, memorandum of understanding, or other federal mechanism recognizing the country's adherence to current good manufacturing practices for pharmaceutical products. The location, names, and titles of all principal corporate officers and the pharmacist who serves as the prescription department manager for prescription drugs exported into this state under the International Prescription Drug Importation Program. Written attestation by an owner or officer of the applicant, and by the applicant's prescription department manager that the attester has read and understands the laws and rules governing the manufacture, distribution, and dispensing of prescription drugs in this state. A prescription drug shipped, mailed, or delivered into this state meets or exceeds this state's standards for safety and efficacy. A prescription drug product shipped, mailed, or delivered into this state must not have been, and may not be, manufactured or distributed in violation of the laws and rules of the jurisdiction in which the applicant is located and from which the prescription drugs shall be exported. A current inspection report from an inspection conducted by the regulatory or licensing agency of the jurisdiction in which the applicant is located. The inspection report must reflect compliance with this section. An inspection report is current if the inspection was conducted within 6 months before the date of submitting the application for the initial permit or within 1 year before the date of submitting an application for permit renewal. If the applicant is unable to submit a current inspection report conducted by the regulatory or licensing agency of the jurisdiction in which the applicant is located and from which the prescription drugs will be exported due to acceptable circumstances, as established by rule, or if an inspection has not been performed, the department must conduct or contract with an entity to conduct an on-site inspection, with all related costs borne by the applicant. Accept a current and satisfactory inspection report, as determined by rule, from an entity approved by the Board, or accept a current inspection report from the United States Food and Drug Administration conducted pursuant to the Federal Drug Quality and Security. The Department shall adopt rules governing the financial responsibility of the pharmacy permittee. The rules must establish, at a minimum, financial reporting requirements, standards for financial capability to perform the functions governed by the permit, and requirements for ensuring permittees and their contractors can be held accountable for the financial consequences of any act of malfeasance or misfeasance or fraudulent or dishonest act or acts committed by the permittee or its contractors. Take a break, and we hope to see you in the next video.